Welcome to Techin5, where you can get your tech news in 5 minutes. I'm Madeline.
And I'm Christina. This is your weekly download. We're excited to talk about today's news, which is a big headliner. It's the case of Google and Oracle. In this particular case, on April 5th, the Supreme Court sided with Google in allowing it to use an API code based on Java for a development of the Android platform. This landmark case leads and opens up the way for APIs to remain uncopyrighted and unprotected so that future development can be permitted on platforms that are allowed and accessed through APIs. So APIs, what they are, is a way for software developers or software companies to protect their source code, which is their intellectual property, but still allow users without too much difficulty to connect into the source code to perform particular functions. So APIs are a way that we connect software to software, and we allow integration between software platforms in what we would call an app-centric environment. So up until this case, which has been under discussion for over 10 years, there was really, APIs was your user-friendly way of saying software companies want to play well with each other, and they want to be able to allow innovation to occur and for communication to occur. It really helps to sell your software when you say, I have an open API that you can use. But this landmark case protects the use of this API for Google on what was Oracle's brainchild with Java. So you come from a background, Madeline, that talks a lot about cybersecurity and IP and whatnot. So what are your thoughts on the ruling on this case?
So on this case, it was very interesting to see because we knew already that a computer program is protected by copyright because somebody has sat there and wrote out the code, and there's a lot of creativity that has to be behind that. When it comes to APIs, though, there isn't creativity. You're just kind of pulling somebody's basic data information and pulling that into yours. And a lot of times, especially over the past 10 years, a lot of companies have been using a lot of APIs just to build better systems and to create new ideas and create ways of bringing more data together so it's better for the consumer, better for business. So I actually am kind of glad that they didn't say that APIs are under this copyright law because that would really have stifled innovation if we would have done, said that you had to go ask for permission or pay a fee or pay for licensing. And because there's a lot of times where there's not rules built around what you can charge, right? There's not governance around that kind of level. Then you could have had somebody who had really valuable data that was charging up the wazoo for it. And so that wouldn't have been fair either. And again, it stops innovation because you can't pay for that. So in this case, I think it's something that saved the tech industry. In fact, in some of the headlines around this, the Supreme Court saved the tech industry because this was their ability to keep that innovation going. That's what we're constantly going for. Any new program that you see, any new service that might be out there, it's using API a lot of the time.
Yeah, absolutely. And what's interesting in this case is that the metrics on it, one of the measures that they did was on how much of the actual API itself and the source and the code, not source code, but the code of the API was used in the development of this Android platform. So when you got down to I think it was 11,500 lines of code versus several million lines of code, the actual percentage was 0.4%, not even a full percentage of the final product was comprised of this API. So it really is negligible in terms of the percentage of the final product. So I think that while, we all want to be protective to a certain degree against competitors, but at the same time, there's kind of this unwritten, fellowship amongst software and tech users where we want to try to make things a little more open source. We want to be able to collaborate and use the tools that are developed, the intellectual property that's developed by other companies, and give them credit for it while we use that as a launching platform for future innovation and pushing those boundaries of technology even further.
It's the idea of the frenemy, right? We're friends, we're enemies, but we're going to do this for the better of technology. And
Absolutely.
unfortunately, in this case, and for 10 years, I mean, you're looking at two companies who just don't get along. So then that's gonna create some tension. But I think at the end of the day, the Supreme Court, in my opinion, took a good ruling to protect technology.
Absolutely. Consumers are winning in this case, big time.
We are, for sure.
Great talking about this subject with you, Madeline, as usual. Be sure to like and subscribe to Techin5, everybody, and we look forward to seeing you on the next episode.
And if you have any comments about your feelings about the Supreme Court ruling, let them down in the comments section and let us know how you feel.
Absolutely.
Thank you so much, Christina. Always a great time.
See you next time.
Bye.
Bye.